Welcome to Candidly Patentable, Navigating Ethical Practices in IP Law. Today's presentation is an ethics course that focuses on the special ethics duties of IP lawyers, and especially those of you who practice in patent law. My name is Emil, and I'm a partner at McCabe Ali, LLP, where I focus my practice on the intersection of IP and ethics matters. In doing so, I represent practitioners before the Office of Enrollment and Discipline, and also aid lawyers and law firms in navigating the ethical nuances of practice before the USPTO. As an outline of today's presentation, we're going to be talking about the USPTO's regulatory power. For a moment, I want to invite you to understand that even if you are not a registered patent lawyer, for example, maybe you're a patent litigator, or you are a trademark lawyer, you might still be subject to the USPTO's regulatory power. We'll also talk about the role of OED, and we're not talking about the Oxford English Dictionary, we're talking about the Office of Enrollment and Discipline at the Patent Office. We'll also talk about special candor obligations for those of you who practice in patent matters. We'll talk about inequitable conduct and how that can really impact your license and your reputation. And of course, we'll talk about conflicts of interest, and especially those nitty-gritty subject matter conflicts. And finally, if we have time, we'll talk about the use of AI. I know ethics can be very boring, and as an ethics lawyer, I will wholeheartedly agree with that. But what I would like from you is some interaction. So if you have questions, while I'm not here to provide you with legal advice, I will be looking on my screen to see if anyone has any questions, and I will try to incorporate them and answer them live, so please keep them coming. So, talking about the regulatory power of the USPTO. What is practicing before the USPTO? Unlike most state bars will say, if you're practicing physically in a state, you are subject to their jurisdiction. Or if you are licensed, you are subject to their jurisdiction. The USPTO is a tad bit different. They're saying that if you engage in any practice before the USPTO, you are subject to their jurisdiction. And being subject to their jurisdiction or practicing before the USPTO would include anything from filing a patent application, filing a trademark application, appearing in a disciplinary trial, filing a FOIA request. Any of those things makes you subject to their rules. So why is that important?